Veterans, are you getting everything you are owed? This article is by Tony Hinson of Sherrard McGonagle Tizzano Lind, an elder law and estate planning attorney. As a veteran myself, I am fortunate to work with many fellow service members in developing their estate plan and exploring any potential benefits available through both the Department of Defense and the Department of Veterans Affairs. One of the most often overlooked but potentially life-changing benefits is aid and attendance. This program has traditionally used a household income cap to determine eligibility and to determine the amount of the benefit. With a general limit of $80,000, but no set asset limit, claims approvers often applied inconsistent and arbitrary standards in reviewing applications. The rules for eligibility for AA, that's aid and attendance, changed significantly in 2018 and applied to all new applications. Let's start with general test for eligibility. The veteran applying for this benefit must be 65 years of age or officially disabled. The veteran must have 90 days of active duty service, of which 1 day must fall within the eligible wartime periods listed below on the chart, and their discharge must not be determined to be dishonorable by the VA, Veterans Affairs. The veteran must be disabled so that they require assistance with activities of daily living, but their disability need not be service connected. Finally, a surviving spouse applying for benefits, if not a veteran themselves, must have been married to the veteran at the time of the veteran's death and must not be remarried at the time of the claim. Income eligibility test. Generally, the joint countable income of a veteran and spouse must fall below the maximum pension available under the program they are applying for benefits. For a married couple applying for aid and attendance, that current maximum for 2020 is $27,549, and the available pension would be the difference between the maximum available and the couple's countable income. However, there are certain deductions from gross income that are allowed when computing countable income, and some income sources are not included. Notably, unreimbursed medical expenses over 5% of the maximum available benefit may be deducted from income, and Social Security income and welfare benefits are not counted in income. Asset eligibility test. Under the new rules, the VA uses the maximum community spouse resource allowance, also referred to as CRSA, as a bright line test to determine the net worth limit for aid and attendance eligibility. Currently, this amount is $130,000, actually $130,733. Much like other such limits under federal law, the amount is adjusted annually for inflation. Additionally, there are several rules used to determine the applicant's net worth. First rule, countable income included in net worth. The annual countable income of the applicant is included in the net worth computation. Number two, primary residence excluded from net worth. The value of the applicant's home and accompanying real estate not to exceed 2 acres is excluded from this asset limit. If the home is sold, the proceeds must be used to purchase a new home in the same calendar year, which would result in a very tight time frame if a home is sold at the end of the year. If the residence is offered as a rental, the rental income is included in countable income and also included in net worth as explained above. Number 3, all other assets included in net worth. All other assets owned by the applicant and spouse are included with any debts or liens deducted from such assets. It is important to note that there are no qualified annuities available to exclude as with Medicaid, and all assets are included regardless of whether they are listed for sale at the time of the application. Notably, transfers made to a single premium immediate annuity, in parentheses, a Medicaid annuity, will trigger a possible penalty under the look-back period, discussed below, for the entire amount transferred to the annuity. This brings us to 3-year look-back rule. The VA imposes a 3-year look-back period for disqualifying transfers with a maximum 5-year penalty period as a result of such transfers. If the VA finds that a disqualifying transfer occurred within the look-back period, a penalty is imposed. The penalty is a period of ineligibility which runs from the date of the disqualifying transfer. If the VA imposes a penalty for the transfer, the applicant has 60 days to recover the asset and must, within 90 days, provide notice to the VA that the assets have been returned. Penalty period. To compute the penalty of ineligibility due to a disqualifying transfer, you take the portion of the value of the asset which, if not gifted, would have caused the applicant to exceed the asset eligibility limit and divide that number by the maximum monthly aid and attendance benefit payable to a veteran with one dependent, regardless of this particular veteran's dependent status. That number rounded down is the number of months the applicant is ineligible from the date of the gift. As an example, assume a couple has a net worth of $150,773 and gifts away an asset worth $25,000. Before the gift, the couple had an excess net of $150,773 minus $130,733, which equals $20,000. The maximum monthly aid and attendance benefit for 2019 for a veteran with one dependent is $27,549 divided by 12 months, or $2,296. Dividing 20,000 by the $2,296 results in an 8.7 month penalty period, rounded down to 8 months. This period then runs from the month after the transfer. Dependent indemnity compensation. Completely separate from the aid and attendance is an exciting benefit available to surviving spouses, and in some cases, parents and children, of deceased service members. Unlike aid and attendance, dependent indemnity compensation, also known as DIC, is not limited by income or assets. It is available if the service member or veteran dies on active duty, dies from a condition which is service-connected, dies after being deemed 100% disabled for 10 years for VA purposes, was a POW and 100% rated for 1 year, or dies due to VA medical negligence. The benefit ranges from $1,358 per month to well over $2,600 per month. It is important to remember that many ailments are automatically deemed service-connected for Vietnam veterans due to Agent Orange exposure. I encourage you to visit www.va.gov and review the pages regarding DIC. Seek assistance. While the aid and attendance and DIC rules may seem burdensome or complex, veterans and their dependents should explore every benefit available, including aid and attendance and DIC. I encourage you to seek help of the great programs and services available to you, such as www.veteransaidbenefit.org and also www.veteranaid.org. Eligible wartime periods. The VA uses the following wartime periods to determine eligibility for VA pension benefits. The first is Mexican border period, which is May 9th, 1916 through April 5th, 1917. World War II, April 6th, 1917 through November 11th, 1918. World War II, December 7th, 1941 through December 31st, 1946. Korean conflict, June 27th, 1950 through January 31st, 1955. Vietnam, February 28th, 1961 through May 7th, 1975. In the Republic of Vietnam, otherwise August 5th, 1964 through May 7th, 1975. And lastly, Gulf War, August 2nd, 1990 through a future date.